Welcome everyone to Stop Search Detain, Police Powers on the Street, a webinar presented by Redfern Legal Centre. My name's Nick Manning and I manage the Community Worker Training Program here at RLC. Our presenter today is Sophie Lever. Sophie, would you like to introduce yourself?
Hello and thank you everyone for joining us. I'm Sophie Lever. I'm a solicitor in the police practice at Redfern Legal Centre. I'd like to acknowledge the Gaimagal people, the traditional owners of the land where I'm coming from today.
Thank you, Sophie. I'd like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the land that Redfern Legal Centre's offices are based upon. Today, I'm on the land of the Darug people, so I also acknowledge them and elders past, present and emerging, and extend that respect to other Indigenous Australians who are present.
So we have quite a lot to get through today in this discussion about police powers on the street. I'll be starting with a quick rundown on where police get their powers, then moving on to identity requests. So when police stop you in the street to ask for your name and address and perhaps a quick chat. Directions, such as a move on direction. And then we'll be talking about searches, what's involved in personal searches and strip searches, and seizing property that comes adjacent to those searches. And then I'll go through the process and the options for police complaints to the LECC, which is the Law Enforcement Conduct Commission, and potential compensation claims. And you'll see at the bottom, we have a link for the resources that might help you that come with this webinar.
Might also, sorry, Sophie, I might just jump in and fully explain that we can't see you. Nobody can see each other except for Sophie and myself. So Amber, we cannot see you folding your washing. Thanks.
But good multitasking. So we'll head to the next slide and discuss the source of police powers. So on the next slide again, we have a few of the main acts where police derive their powers from. And today I'll be focusing on the top one, which is the Law Enforcement Powers and Responsibilities Act. And this is a piece of legislation that sets out what police can and can't do. And this is the most important one for your everyday interactions on the street with police. Police do get their powers from other legislation, such as the others that I have listed here. And of course, at the moment, we're seeing police derive their powers from the public health orders. And questions may arise to do with that. But otherwise, I'll focus on the Law Enforcement Powers and Responsibility Act, which we call LEPRA.
Yes, Margaret asked exactly that, and you've answered it, that the COVID powers mainly come from the public health orders. That's right, isn't it?
Yes. Excellent. We can touch on them later. So on to the next slide, please, Nick. Thank you. So identity requests. Police do have the right to ask for your name and address, but most of the time you don't have to answer. And I think there's a lot of confusion surrounding when you have to respond to police, especially when they're just stopping you on the street for a quick chat. In most scenarios, you do not have to respond, but there are a few situations where you should provide your name and address, and they are when police want to give you a court attendance notice, when they want to give you a direction to leave a place, if they reasonably suspect you may have information about an offence that has taken place, if you're driving, or in some other certain situations. So we'll just go on to the next slide. And I've got it. Yep, so the safeguards are in place to stop police having unfettered powers. So when exercising a power such as stopping someone or asking them for their name and address, police must always adhere with the safeguards. So they must show evidence that they are police. They must give their name and place of duty, explain why they're asking, and they must give a warning that it's an offence not to comply. So they must do this before exercising the power, or in some situations, as soon as practical after. So I've just got some examples in the next slide to help you understand the difference between when you do and when you don't need to respond. So example one, James leaves his house and walks towards the train station on his way to work. Police stop James and demand his name and address. Does James need to give them his name and address? And did the police do anything wrong in this scenario? So in this scenario, there are no apparent circumstances that would require James to respond. None of the situations that I entailed on the previous slide are in place, and therefore James would be well within his rights to just keep walking on. Further, the police didn't adhere with the safeguards, so they haven't done the right thing when stopping him for his name and address. We'll compare this with the next scenario on the next slide, please, Nick. So Julia leaves her home and walks towards the train station on her way to work. Police stop her and tell her that there was a violent incident outside her home 5 minutes earlier, which she may have witnessed. Police ask her for her name and address. So in this scenario, I would say that Julia does have to give her name and address because the police may have reason to believe that she witnessed an indictable offence 5 minutes earlier. So in this scenario, they have the right to ask her for her name and address, and it's best to give it. Even if she doesn't think that she saw anything to do with the incident that happened, the police still have reason to believe that she might have witnessed something, and so they have a reason to ask. So it would be in her interest to give her name and address. In this scenario, though, they still do have to adhere with the safeguards. Okay, so on to the next slide.
I'll just jump in because two people have reminded me to let you know that we will provide this PowerPoint file. It will be uploaded to the resources page a little bit later today. Normally we do that in advance, but yes, we're a little bit behind. Apologies there. Thanks.
Thanks for that. Okay, so directions are orders to stop doing things or to leave a place for a period of time. And these can only be made in public places. So these are places that are open to everyone, places with some entry restrictions, or places which are actually private property but do not belong exclusively to one person. The most common direction that we see, and I'm sure that you would see as community workers, is the move on direction. And this is only to be given if police officers believe on reasonable grounds that certain criteria apply. So the legislation doesn't actually say what types of directions can be given. But it must be reasonable in order to reduce or eliminate the issue. So we'll just move over to the next slide, please. So a move on direction can be given if the police officer believes on reasonable grounds that the behaviour or presence in the place is obstructing another person or traffic, constitutes harassment or intimidation, is causing or is likely to cause fear to another person, or is for the purpose of supplying or obtaining a prohibited drug. So there are safeguards that do apply to giving a direction. And the most important one that we think is the police have to give a warning that it's a failure to comply, that it's an offence if you fail to comply with the warning, so with the direction. So a lot of people do get charged with a failure to comply with the direction, but if they weren't given that warning either prior to the direction or as soon as reasonably practical after, then they have a right to challenge that, either a fine or a charge in court. So as I said, there's no rules or specific details in the legislation which say what type of directions police can give, but it must be reasonable to reduce or eliminate the issue that's taking place.
Do you have an example of perhaps something that might be unreasonable off the top of your head?
Yeah, so it's just about a direction that has to be proportionate to the action. So if somebody is in a public place and they are disturbing another group of people, so if somebody is displaying unruly behaviour, a move on direction to another area or getting them to cease making a loud noise or singing or something that is disturbing somebody else or swearing, that's reasonable and proportionate to the behaviour that they're exhibiting. But getting them to leave the entire area if it's somewhere where they live and not come back for a day or 5 hours or something is disproportionate response to the actual issue that's presented.
Yeah, I think I remember a client that we had at Redfern Legal Centre where they were told to stay 5 kilometres away from the Parramatta CBD for a period of maybe it was a week or something, and in response to some, minor disturbance. So that might be an example of going a bit overboard.
Absolutely, and it's disproportionate to what's actually needed to address the issue. So obviously it's hard when there aren't specific rules around that, but it does require a sense of logic. Okay, so next slide, please. Okay, so we'll just talk about searches under LEPRA. So there are different powers within LEPRA to conduct different types of searches. So the main one that you'd see on the street, the stop, search and detain, is set out in section 21 of LEPRA, and that's what I'll be focusing on today. But there's also a search by consent, which I'll discuss in a bit. And then there is a search on arrest, search in lawful custody, and search pursuant to a warrant. But we won't be discussing those in details today because they're not your common street power types of searches. So we'll pop over to the next slide, please. So a search by consent, which is in section 34A, this is a fairly contentious issue, as under the legislation, police can conduct a search on a person who consents, even if the other conditions that are usually required for such a search haven't been met. So in my mind, it's quite a sneaky way to conduct a search on someone, because in the past it's been accepted that certain questions that people have answered, such as, can you show us what's in your bag, or would you mind emptying your pockets? If someone says yes, it's sometimes been accepted that that person has displayed their consent to a search, and therefore the other criteria become irrelevant and the search is lawful all of a sudden. To me, that's extremely problematic because people are likely to comply with demands or questions when they're confronted by the police and when they don't understand that their response is then going to be taken as consent to conduct the search. So some people unknowingly give consent to an otherwise unlawful search, and that's an easy mistake to make. And I think that's a little bit of a glitch in the legislation that needs to be looked at. So it's important for people to be aware that they can say no to those kinds of requests, even if they're very casually put by police in the course of a discussion. So you can always assert that you do not consent with a search. Moving on to the next slide, the section 21, stop, search and detain. So the police may stop, search and detain you if they suspect on reasonable grounds, and we'll go into what that means later, but that you have any of the following. So stolen goods, weapons, something used in connection with an offence, or a prohibited drug. So whenever the police exercise the power to conduct a search, they must hold the relevant state of mind, i.e. that reasonable suspicion. So they must suspect on reasonable grounds that those things apply. So we'll just pop over to the next slide, please. So they must hold that state of mind. They must comply with the rules for searching, which I'll detail later. And they must comply with the safeguards, and they must make a record of the search. The final one, it's something that we see that's quite lacking at the moment. Very often police don't record the search, which we find to be problematic when it comes to clients later relying on the fact that it took place or how it took place, whether that's relevant in their criminal proceedings or to assert their civil rights. So this is an issue that I've noticed and I think is being looked into by the Law Enforcement Conduct Commission about the need for improvement in record keeping. So just to go further into that state of mind that's required by police when they conduct a search, we'll just pop over to the next slide. So a reasonable suspicion is that one of the circumstances that I set out before apply. For example, that somebody has drugs on them. That reasonable suspicion involves less than a belief, but more than a possibility. So it's sort of a vague way to describe it, but there has to be some factual basis for the suspicion based on what's in the mind of the officer at the time. So we've seen the courts for quite a long time grapple with what this means and what counts as reasonable suspicion, and it can be a fine line. So on the next page, I'll just touch on some quick tips for dealing with police. So police conducting a search, you can always ask if it's voluntary or whether they're requiring it. If they're requiring it, you can ask why. So it's almost asking them to fulfill the safeguards, which they should be fulfilling anyway. Sometimes it can be better to comply. So you can assert that you do not consent to a search and asserting your rights, but then it might be in your best interests, if the police are going to conduct that search anyway, that you should comply with what they're telling you, because we've seen if you physically refuse a search, it could lead to further charges of hindering police or resisting police, and that's not in your best interests.
Yeah, just on that, Sana's asked, what would the police do next if one refuses the search and you haven't done anything illegal? And so there's a big distinction here, isn't there, between verbally refusing to comply with the search and physically trying to stop the search. Do you want to just touch on that?
So I guess refusing is a little bit different to stating that you don't consent. So stating that you don't consent is an important way to make sure that they're not doing one of those sneaky searches by consent. And it's putting on the record, especially if it's being filmed, that you do not consent to the search. But physically resisting it is, yes, definitely a different thing. And if you say you don't consent to the search, police can and very often will still proceed with a search, I guess, against your consent, if they believe that all the other criteria are met. So if they still hold that relevant state of mind, and if they think that you, for example, have drugs on you, or you were in one of those scenarios that was detailed before. So, and I think the question that Nick brought up was even if you haven't done something illegal. And that's really tricky because, yes, often searches are conducted when you haven't done something illegal. But if there is reasonable suspicion, or if the police officer has that state of mind that you might have done something or have something on you that's in that list, then they're allowed to proceed with the search.
I think this is one of the difficulties that the general public has, which is that they often know that they've done nothing wrong, but the police are allowed to take certain actions against people who are at that point merely suspects. For example, they can arrest people who have done nothing wrong, like they have to. I know we're not talking about arrest right now, but it's the difference between what's in the mind of the person and what's in the mind of the police.
Definitely, and that's why that reasonable suspicion sort of slightly grey area has been put under such scrutiny in the courts and in Parliament, because someone wearing this is a terrible example, but someone wearing a Bob Marley hoodie and walking down the street, that's not enough to form a reasonable suspicion in somebody's mind that they're smoking marijuana. It has to be a much more factual basis. So you can be walking down the street knowing you haven't done something illegal, but if the officer has a relevant state of mind based on what they see in front of them at the time, then they can lawfully proceed with a search. But that's then post-incident, that can become the subject of debate, whether that's in a civil claim or a complaint or in criminal proceedings. So that's why there's often a lot of discussion about whether a search was lawful or not, and whether everything that we're discussing today was correctly complied with.
And I'm glad that you'll come back to, court cases and so forth later, because someone has asked about how do you prove this stuff in court if there's no witnesses. So we'll come back to that.
Yeah, well, to quickly touch on that, the answer is it's really difficult. So you can request that officers turn on their body camera footage. It's not a strict requirement in the law, but the courts have been critical of officers not doing it. And as I said, the LECC is very critical of officers not keeping records of searches. So if I were being searched, even though it's an invasive thing to be filmed, I would want to ask the officers to put on their body worn video. Or if I had a friend there, I'd ask them to film it. We'll touch on how that's allowed and issues around filming police in a bit. But yeah, if there's a way you can ask for it to be filmed, I always would. Okay, so moving on to the next slide. Just going into some details about what a personal search actually involved. So you may have heard the terms body search, frisk search, pat down search, and they're all different terms for the same thing. So in a personal search, police can pat you down. They can ask you to remove outer clothing, so not your inner clothing, but just hats, shoes, coat. They can ask you to shake your hair. They can't do this for you, but they can ask you to do it. They can ask you to open your mouth. They can look in your pockets and examine your possessions, or they can run a metal detector over your body. So in the next slide, we'll just go through, this is what they can't do. So they can't ask you to remove your inner clothing. As I said, they can't pull or lift your clothing away from your body, and they can't examine your body. Those things would amount to a different kind of search. Okay, so on the next slide, we'll just discuss the safeguards that are put in place for a personal search. So these are rules that are put in place to make sure that the search is being conducted lawfully. So before conducting a search, police must provide evidence that they're an officer. They must give you their name and place of duty, and they must give you the reason for the exercise of the power. And this information must be provided as soon as reasonably practical, or if there is a requirement, such as a requirement to remove something, before that requirement. So on the next page, we'll go into a strip search.
Can I just jump in and just flag the content that we're going to go over? Quite a few people asking about children and young people, and I know you're going to talk about that in the context of strip searches, but is there anything to say about the personal searches, the content you've already covered, where there's any distinction with children and young people compared to adults?
That's a good question. The strip search, because it is a particularly extreme form of policing, there are extra safeguards for children and young people. So I'll touch on those, but basically children under 10 shouldn't be strip searched, and children between 10 and 18 should have a guardian or representative present, although there are exceptions to that. But from my understanding, and I would like to double check this and let you know by the end or in an email, the same safeguards for children don't apply to a normal personal search.
The non-strip search, okay.
So a strip search. Police can conduct a strip search if the officer suspects on reasonable grounds that the strip search is necessary for the purposes of the search and the seriousness and urgency of the circumstances make it necessary. So that's an extra rule that's put in place because a strip search is such an invasive procedure, and it should only take place in an exceptional circumstance. So those things apply because it shouldn't be an everyday policing act, and especially out on the street. It's a pretty extreme action for police to take, and the seriousness and urgency need to be present for it to be required. So on to the next slide. So I'll just touch actually that I mentioned seriousness and urgency. I should say that the legislation doesn't actually go into detail about what this means, but the courts have accepted, and logic would probably tell us that seriousness and urgency could be situations where police might believe that somebody has a weapon concealed that they're likely to hurt themselves or somebody else with, or they might use to escape police custody. So that would be a scenario where they need to conduct, or they say they need to conduct a strip search on the street because something worse could happen and it's serious and urgent enough that it needs to be conducted there. So a strip search is something that goes beyond a personal search, the type of search we spoke about before, and it can include asking a person to remove their clothing to allow a visual examination of the body, asking a person to pull out their waistband, but not doing it themselves, and asking a person to move their body or parts of their body for visual inspection. So in the next slide, we just set out the rules that are set out in section 32 of LEPRA that are there for the preservation of dignity and privacy. Obviously, a strip search on the street, by most people's standard, isn't a dignified or private thing, but these are put in place to make it the most dignified and private as possible. So a police officer conducting a search must inform the person if and why removing clothing is necessary, ask for their cooperation, conduct the search quickly and provide reasonable privacy, conduct the least invasive search practicable. They must not search the genital area or breasts. The police officer must be of the same sex to conduct the search, and the search must not be conducted while the person is being questioned. In the next slide, we'll just go over the additional safeguards that are in place for strip searches. So it must be in a private area. So if someone's being stopped and detained on the street and they're on a busy street, the safeguards are in place that police must take them to a reasonably private area. So whether that's, somewhere more covered or not exposed and not just in a busy public area. It must not be in the presence or view of members of the opposite sex or a person who is not necessary for the search. It must not involve search of body cavities or examination by touching the body, and must not involve the removal of more clothes than reasonably necessary. So I guess the body cavities one has been contentious because there's some debate about whether a squat and cough is allowed, and I would say that it's not. And that has been a source of a bit of debate in the past. So onto the next page, some further safeguards. A parent, guardian or representative may be present, and children aged 10 to 18 and people of impaired intellectual functioning must have a parent, guardian or representative present. The issue with that one is that the legislation does allow police to opt out of that particular requirement about a parent or guardian if the situation demands it. So if there's not time to wait for a parent to be present and they need to conduct the strip search because of some pressing situation, again, something like a weapon, they can opt out of that requirement to have a parent or guardian there. So that's a bit of a tricky safeguard when there's a legislated option to not adhere to it.
Do you want to comment on the publicly aired cases of young people under 18 at music festivals who've been strip searched without their parents present?
Yeah, so that's something that Redfern Legal Centre is working on at the moment, and it's something that has been subject of a lot of public scrutiny and in some of the inquiries. And a lot has been uncovered about the misunderstanding and misapplication by police of the rules around strip searches. And there's a huge public discourse now about how traumatic strip searches can be on young people, vulnerable people, people who maybe have a background of domestic violence or assault. And I think it's something that is highlighted now. Yes, there's a focus on some events that happened at music festivals involving young people, but strip searches on young people isn't anything new, and it's been happening in rural and remote communities and to a lot of marginalised groups and against a lot of First Nations communities for a long time. So I think the highlight on strip searching young people is well overdue, and the discussion about it is very welcome. Okay, onto the Next slide. So just some quick tips if you or a client are subjected to a strip search. Similar to the previous ones, you can ask the officer for their name and station. You can tell the officers that you do not consent to the search. You can ask them to turn their cameras on. And then this is tricky in the heat of things, but you can try and remember all the details about what happened, where it was, so that later, if you need to recall and discuss it with a lawyer, you have as much information as possible. So if something has happened with police and you didn't have a friend or family member there and you feel it wasn't quite right, once you walk away from the situation, try and take a mental note or a physical note of everything that happened, a description of the officers, any names that you can remember, what station they came from, where you were, what time. It just helps you to be equipped with as much information as possible. And that in turn helps a lawyer to uncover as many of the facts as possible.
Can I just ask a few questions on behalf of the audience about cameras and filming? Working backwards, firstly with the strip search, is that actually filmed by the police?
It can be. In practice, we don't see that it is all the time, but it has been criticised by the courts, etc., that police don't do it. So you can request for them to turn on their cameras. Quite often they don't have them working, or there are situations where it just doesn't happen. But yes, you can ask to be filmed when a strip search is being taken place.
So someone else has asked, and this might apply to either strip searches or personal searches, but can you ask for them to turn their camera off?
Yes, I can. You can. Again, it's not in the legislation, as far as I'm aware, a requirement for them to film it or not. So it would probably be a situation by situation basis, but you can assert your preference, yes. But it's probably in your interests, even though it's uncomfortable, for it to be filmed, so that if the safeguards weren't complied with, or if it wasn't conducted lawfully, you can then access a copy of it and use that to empower yourself later down the track.
And Margaret's asked if you're allowed to film the search yourself. I imagine with the strip search that would be practically difficult or impossible.
Difficult, yeah. So I guess it would.
Yeah, sorry.
In a scenario where you're with a friend or someone out and about, if you can ask them to start filming. In practice, this often gives rise to or sometimes inflames the situation, because police quite often get angry when you try and film them, but you can film police in public places. So there's an exception to the Surveillances Act, which allows you to film a conversation with another person if it means you're protecting your legal rights. So in a scenario where you're being subjected to a strip search, in my view, that definitely comes under the need to protect your legal rights. So you can film it. And I think by virtue of that, you should be able to ask a friend to film it, because it's physically near on impossible to film yourself being subjected to a strip search.
And so equally a personal search or a stop and question, and we see this where the person or their friend or a bystander films it. Can a stranger, like strangers do film these interactions, but can they get in trouble with the police for doing so?
Yeah, that's a fine line. No, I mean, if you've filmed an interaction in an effort to help somebody else protect their legal rights, I think that's an extension of that exception in the Surveillances Act. You can't get in trouble. They might tell you to stop filming. In some cases, we've seen them try and get people to delete things, which they can't do, and they can't seize your phone just because you're a bystander filming something. So I would always encourage people to try and record their interactions with police. You can do it discreetly. You don't have to. It just, yeah, you have a right to.
Okay, thanks.
Okay, so we'll just move on to the next slide. Just back to strip searches. So there are, I mean, and I touched on this when I spoke about the music festivals, etc. But we've seen in recent years, or I guess in the past decade, a huge spike in the amount of strip searches used. We think a lot of that has to do with a misunderstanding by police about the requirements and about the powers that they have. It's not being used as a last resort, which it really, really should be. It should be something that's, because it's an invasion of your rights and your personal liberty, it should be something that's only done in exceptional circumstances. And we're seeing that that line is blurred sometimes. We're seeing it used disproportionately against young people, First Nations people, people in marginalised communities, as I'm sure a lot of our listeners today are seeing as well. And as I've touched on before, there's a lack of clear record keeping about the reasons for a strip search or about the fact that it even took place. And we're seeing it sometimes used for intimidation and humiliation rather than for the legal reasons. And of course, that's unlawful. And as I touched on before, strip searches can be quite traumatic for people. They're not just embarrassing, they can be, they can trigger a lot of past experiences, and they can have a lasting impact for, especially for young people and people developing their sense of trust with the police and authority. So yeah, it's a topic fraught with issues. Okay, so just pop to the next slide. So if someone has been subjected to an unlawful search, so a search where the officers didn't comply with all the LEPRA rules and the safeguards, then that can have implications for that person's rights in a civil sense and in a criminal sense. So for example, if an unlawful search takes place during which something incriminating is found, such as drugs, and then that leads to criminal charges against a person, that's something that the defense lawyer will want to raise in the proceedings, as it could lead to the charge being dismissed. And then in terms of your civil rights, an unlawful search may amount to false imprisonment, assault and battery, or any of those individually, and it might give rise to a civil claim, which is something I'll discuss in more detail, but it's something that people can talk to lawyers about after an incident. On to the next slide, please. Okay, so just quickly to touch on this, sort of on the topic of phones, the LEPRA provisions empower police to seize property found as a result of a search. These are pretty broad powers, so it could include seizing your phone, because that could be something found as a result of a search. The legislation doesn't, so it empowers police to examine your property during a search, but it doesn't necessarily say what examine involves. So that again is a bit of a contentious issue, because I would say that it doesn't involve examining the contents of your phone. So going through your data and looking for further or any incriminating material. I would say that that goes beyond mere examination of property and would require a warrant or other special conditions to apply. So because of that, I would advise people that you do not need to consent to them looking through your phone, and you do not need to give a password if they ask for one. Okay, on to the next, please. Okay. So options for what you can do if you've been subjected to police misconduct or a misuse of police power. There are several options, each with different outcomes and different objectives. So the first is the complaints procedure. You can complain directly to the police or to the Law Enforcement Conduct Commission. So we call that the LEC. The alternative or additional options, you can do those and then proceed with the third option, is a compensation claim. And I will discuss that in more detail shortly. And the other main thing you can do, which is what people are doing today and hoping to empower their clients with, but is just learning about your rights and teaching your clients about their rights so that they're empowered to respond to a situation appropriately and to seek legal advice if they think something wasn't done right. So on to the next slide.
I might just briefly comment on learning about your rights. And in a past life, I worked with a lot of youth workers to educate young people about their rights with police. And it's such a tricky area because some of what you're saying is you can say no to X or Y or Z, but some of what you're saying is it may be you can't physically resist A, B, and C, and you might choose to comply with G, H, and I and deal with it later. And it's very nuanced. It's very complicated.
Yeah, it is really nuanced, and it is really difficult to say, okay, well, these are your rights, go and assert them. But actually in practice, it's probably in your best interests to do this and comply here, but not here. So I think it's about empowering people to understand the law and what the police have the power to do, but also empowering them to know how to respond in a way that's in their best interests. But on top of that, empowering them to know that they have avenues for redress if something has gone wrong. So getting the right referral pathway so that they can speak to someone at a community legal centre about the situation, even just to find out if their rights were infringed upon or not. So knowing that they have avenues to speak to people about what happened rather than just letting police use or abuse their powers as they want. But you're right that it is a really difficult area, especially for young people, and the onus is on us to empower people with knowledge about their rights, but the onus is really on the police to apply their rights correctly and to work within the limits of their legislated powers. So it's both sides.
Yep.
Okay. So police complaints. They don't have to involve conduct that was strictly unlawful or illegal by police or that would necessarily amount to a tort claim in the courts, but they can involve things of a lesser degree that just weren't right or that offended someone or felt like a misapplication of the power. So what conduct can you complain about, or what conduct do people usually complain about? So verbal abuse or inappropriate language, discriminatory behaviour, failure to investigate, particularly in domestic violence matters, improper use of force, unlawful searches or arrests, lack of proper record keeping, and failure to give proper information and or warnings when exercising their powers. And as I say, this is not an exhaustive list, so there are things that arise in people's daily interactions with police that they would like to complain about, and they do so. Mental health issues is another one that has a lot of interaction with police that people like to complain about and would like to see change with. So we'll go on to the next slide and we'll just talk a bit more about the complaints process. So the two different avenues for making a police complaint, and you can, I should say, you can do these on your own. There are online portals and information, or you can do it with the guidance of a lawyer and a community legal centre. So for example, Redfern Legal Centre is part of my practice that I help people understand a situation, obtain information and records about that situation, and then make a complaint using the appropriate avenue. But it's not something you strictly need a lawyer to do. It just might help if you want guidance. So you can complain directly to the New South Wales Police Force, or you can complain to the Law Enforcement Conduct Commission, which we call the LEC, which is an independent, so a neutral oversight body. The LEC only investigates the most serious misconduct. Most matters are referred back to the police for investigation, but the LEC may decide to monitor the investigation. Formal complaints must be in writing, And as I say, it's best to seek legal advice before making a complaint, but it's open to you to do it yourself as well. So
Sorry, I might just jump in. Someone asked quite a while ago, or gave the example of their 16-year-old son who was strip searched at a railway station looking for drugs, which he didn't have. His parents weren't informed and no other adult was present. Is that lawful? And if not lawful, how can you report it? So you'd report that via a complaint. Is that an example of what you might?
That's a really good example. I would need to know more details about the exact situation to comment on whether it was unlawful or lawful. But a strip search of a 16-year-old in public without somebody present sounds like it probably wasn't adhering to all of the requirements and safeguards. But as we remember, you have to show the seriousness and urgency of the situation require it. So it would depend on the circumstances as to whether or not that was lawful. But that's a really great scenario to reach out to a lawyer, a community legal centre, for advice, about whether it was lawful or unlawful, and then what rights you have to deal with that situation. So, for example, if that was a query that came to me, I would help that person to obtain the records in relation to the strip search. So if that was a scenario where the police had their body-worn videos on, I would help them make the person make an application for access to that footage. If there were police records made, which there should be, but we know that they aren't always, I would help the person make an application for access to those records. So then we have all the information about the incident. It might be if it was in a public place, we can get CCTV footage. If it happened near a camera or something like that, I think, did you say it was at a station? So from there, we could guide you through the complaints process. So you can complain about the matter directly to the police and then they can investigate the matter, or to the LECC and they can decide whether to take it on or whether to refer it back to the police for investigation. And then, and I'll touch on this in a little bit in another slide, but over and above the complaints procedure, we can then advise you about whether that search was unlawful and amounted to an assault and battery, which could then give rise to a tort claim. So on the face of it, it's too early to say whether it would give rise to a tort claim, but if police unlawfully conducted the search, you may have rights to seek compensation. Further and above that, if something was found during the search and it led to criminal charges, as I discussed before, that's a really good thing to talk to your criminal defence lawyer about, because they would probably want to raise the lawfulness of that search and therefore the evidence that was found during that search as an important part of your defence.
Just on that, Belinda asks, how does a LEC complaint impact on the treatment of evidence arising from an unlawful search at trial?
The short answer is that the LEC complaint doesn't. The time frame of these things is usually that a criminal proceeding would take place more quickly than the unfolding of a complaints procedure. So the lawfulness or otherwise of a search would likely be fleshed out in a criminal proceedings first. So you would talk to your criminal lawyer about that, and they would likely have any records related to the search in your brief of evidence. So it's probably the reverse of the question. It would probably be that the outcome of the criminal proceedings has a bearing on your civil rights and your civil processes. So if a magistrate or a judge were to rule that the search was unlawful and potentially dismiss the charges, that is an added thing that can be put into a complaint, or that could be grounds for a civil claim. So yeah, the answer is that the LEC finding doesn't have bearing in a criminal court that I'm aware of, and would likely come after.
Okay, and Tanya asks, tells us that when she was a domestic violence worker, she made a complaint to the LEC on a domestic violence matter. She got no response. She contacted the station on numerous occasions to no avail. It just went unaddressed. So it didn't give her much confidence in the system.
I'm really sorry to hear that, and not surprised either. It can be a bit of a clunky process. I think it's getting better. The LEC is a relatively new body. It replaced the Ombudsman. And I think at the beginning there was some teething issues. And as I've mentioned, the LEC doesn't take on every case. So they get a huge volume of complaints, and they have an assessments team, and they look through it and decide what they need to take on, which is probably a very small amount. And the rest they send back to the relevant police officers to investigate, and they may oversee that investigation or make findings or request certain things to be looked into. It can be a slow process, and yes, when the matter has been sent back to police, it can be difficult with police investigating themselves and making findings. That aside, I still firmly believe that it's a really important process when you've had your rights infringed, or when you have been subjected to unlawful conduct by police officers. Making a complaint is a really important way to get on the record what's happened. And if enough people make complaints about a similar issue or a similar officer or a similar police station, slowly but surely that data is accumulated and tracked, and can lead to a change in training policies, maybe even action taken against one particular officer. So you may feel that it's frustrating or slow, or what are you going to get out of it? But I think wider picture, it's worth complaining, because it slowly chips away at making systemic change.
Just on that, before we move on, one of our audience have said that they made a complaint about an incident and was contacted to testify in court against an officer. So this person says, keep making complaints even if it feels like it's not going anywhere.
Okay, that's great. That's really good feedback. And yes, it does happen. So, charges against an officer is probably one of the more extreme and rare outcomes that we see. But what an incredible outcome if that's come from somebody making a complaint about what happened to them. So that's really good feedback. And I'm sorry that there's a mix of different reactions to how people feel about the complaints process, and I can only hope that that improves. Okay, so the outcomes. So the police can decline to investigate a complaint for many reasons. For example, too much time has passed or an action has already been taken. So we do advise people to try and make a complaint within 12 months of the incident taking place. It's not a statute of limitations issue. It's just because if you complain about something 10 years after it happened, you're unlikely to get a thorough investigation into what happened and a satisfying outcome. So if they do decide to investigate, an independent officer will take on the case, and at the end, and they say it's usually investigated within 90 days, but we have seen this be drawn out. You'll be notified whether your complaint was sustained or not sustained, and whether any action was taken. So as I mentioned before, that action can include extra training, dismissal, it can require an apology from an officer, or in some scenarios, as one of our listeners mentioned, criminal charges. So we'll pop over to the next slide because I'm aware of the time. So the LECC, they may decide to refer the matter to another agency, or as I mentioned, back to the police. They may request an investigation. They may conduct further assessment inquiries themselves, or they may decide in some circumstances to take no further action. On to the next. So civil claims. So this is a tort claim. The most relevant claims in tort for police misconduct matters are what's called intentional torts, and that's assault, battery, false imprisonment, and malicious prosecution. Malicious prosecution is notoriously hard to prove. So the main ones you would see are assault, battery, and false imprisonment, and they are generally brought about in the district court. And it's best to speak to a lawyer, a community legal centre first, to help, as I said, get all the information about the incident, work out whether the conduct was lawful or unlawful, and work out what your rights are in relation to a civil claim. The limitation periods are 3 years for a personal injury matter and 6 years for a general tort. So those assault, battery, false imprisonments are general torts. So you do have quite a long time frame. And in my experience, people sometimes take that full 6 years to make a complaint or to make a civil claim. And speaking to a lawyer, you will get some more information about the types of compensation you might be entitled to and what the process involves.
And just to build on that and move towards the end of the webinar, when we get these questions from clients at Redfern Legal Centre, we'll sometimes give advice, as you've said, and then refer the client to a private law firm that does this sort of work, and there's several in Sydney that regularly take on this sort of work. And Sophie, is there a no win, no fee type of arrangement possible?
There is, with quite a few of the firms that we work closely with, and that's a really great way to provide access to justice for people who can't afford a lawyer up front. So a lot of the lawyers we work with, they will take on your case, and if they are successful, they will get their fees from the defendant. So in this case, if it's against the police, it would be against the state of New South Wales. So they would get their legal fees from the state if you win, and you get your full compensation. So you don't have to pay legal fees up front. But they'll also talk to you about the different risks and pros and cons of the whole process.
Sure. Okay.
So as I say, it's best to speak to a lawyer about the merits of the claim. So that's about the success or the likely success of the claim and the risks of going to court. And you can try to provide that lawyer or a community legal centre lawyer as the first point of contact about it, a detailed description of what happened, a copy of any relevant police records that you have obtained, or they will help you obtain them if you don't have them, any relevant footage or any statements from people who might have seen it happen. Okay.
We don't have any more time for questions. We have answered quite a few as we go, but we had about 5 times as many questions as we could answer. I'm really sorry about that. We will go through the remaining questions and see which ones we can answer by email, and that will happen in the email that we'll send to all registrants. Everyone who registered will email you when the recording is live on our website, and that will be the place where we'll answer any of those questions that we can by email. I'll just put that slide up. People have asked where they can get legal advice. So Redfern Legal Centre's police complaints practice is statewide, so any resident of New South Wales can get free and confidential legal advice from us on many police complaints matters. We can't do everything, so best thing is to make contact and lay out the situation, and we'll let you know whether we can advise. And if we do, it will be Sophie or one of her colleagues. You can also get advice from other community legal centres and from legal aid. So that's on the screen as well. Did you have any final words, Sophie?
No, just I'm sorry that we didn't get to answer all the questions. Yeah, I'm happy to do so directly, and thank you everybody for being involved.
Yes, thank you everyone. I'll put the resources address back up there, but so there's some good resources online at the address at the bottom of your screen, and we'll repeat that in the email that we'll send you. So anything that you haven't captured, you'll get that from me in an email within the next few days, along with the PowerPoint file and the recording of the webinar, everything you might need. So thank you, Sophie. That was very good, very comprehensive.
Thanks, Nick.
Thank you, everyone. And I will just ask you to stay on the line for a moment for some quick feedback. It takes about 30 seconds. It's very quick, but it's very valuable to us. So if you can stay on the line, that will appear momentarily. So thank you, everyone.
Thanks, everyone.